Yes. My lords, yesterday I was addressing the second of the 7 reasons why we submit that the discretion should be re-exercised by striking the claim out. Now, an important point that's made in the authorities in this area, and I will take your lordships to 3 of those authorities in a moment, but the point they make is that there are some circumstances in which English law takes the view that a litigant forfeits their right to litigate by reason of their misconduct. Where that principle is engaged, and it's often not easy to work out if it is or isn't, but where that principle is engaged, the forfeiture principle, the forfeiture of the right to litigate occurs irrespective of what the substantive claim is for, irrespective of whether a fair trial in the narrow sense is possible, and irrespective of any alleged wrongdoing by the other party. And the 3 authorities to which I want to take your lordships, if I may, to try to demonstrate that are Massoud and Zahour in this court, Arrow nominees, again in this court, and a lecture by Lord Reed, which considers both English and Scottish authorities in this area and identifies some principles. Massoud is at Authorities, Volume 1, tab 20, page 461. Tab 20, page 461. Very quickly to summarize the facts, just to save time. So in this case, the claimant, Mr. Massoud, and entities controlled by him, sought a declaration that they were entitled to be registered as the owner of certain shares in a company called Istil, I-S-T-I-L. At the end of the trial, Mr. Justice Peter Smith found that all the documents relied upon by both parties were forgeries. He said that had the claimant's misconduct stood alone, he would have had no hesitation in striking the claim out as an abuse, applying the Arrow nominees principle. But in the event, he decided not to strike the claim out because the defendants had also forged documents, and to strike the claim out would allow them to walk away with the Istil shares, which the learned judge regarded as inappropriate. One can see the learned judge's reasoning at page 462. It's quoted. Picking it up just above letter F, para 150, in his judgment, he says, if I was dealing solely with misconduct by the claimant, I would have had no hesitation in striking out. And then at the bottom of the page, para 152, where, as in this case, all the main parties are guilty of forgery and perjury, striking out the claim in effect awards victory to a wrongdoer defendant, and the learned judge regards that as unjust, and there was an appeal from that. Now, picking it up at paragraph 73, page 465, perhaps we should start at 71, actually. Having referred to Arrow nominees, this court says at 71, in our judgment, this decision is authority for the proposition. I'm sorry, it's paragraph 71. This decision is authority for the proposition that where a claimant is guilty of misconduct in relation to proceedings which is so serious that it would be an affront to the court to permit him to continue to prosecute his claim, then the claim may be struck out for that reason. And then 73 is a point on which we rely. One of the objects to be achieved by striking out a claim is to stop the proceedings and prevent the further waste of precious resources on proceedings which the claimant has forfeited the right to have determined. Once the proceedings have run their course, it is too late to further that important objective. Once that stage has been achieved, it is difficult to see what purpose is served by the judge striking out the claim with reasons, rather than making findings and determining the issues in the usual way. If he finds that the claim is based on forgeries and fraudulent evidence, he will presumably dismiss the claim and make appropriate orders for costs, In a bad case, he can refer the papers to the relevant authorities for them to consider whether to prosecute for a criminal offense. Just pausing there for a moment, I should say this paragraph 73 was cited with approval by the Supreme Court in the Summers case. And just to give the court a reference to that, you probably don't need to turn it up. Authorities, Volume 2, tab 24, page 577, paragraph 62. And then continuing at 74, the Court of Appeal says, in his note, Professor Zuckerman comments at page 45, the judgment of Mr. Justice Peter Smith, that if the judge had struck out the claims, he would have spared the legal system considerable resources and would have delivered a clear message to those who might be tempted to use suppression, forgery, and perjury to advance their cause. We can see that if an application to strike out had been made at an earlier stage in the proceedings, this might well have been the case. Indeed, Professor Zuckerman himself says that the adoption of the forfeiture approach would require the court to be alert to the possibility of fraud on the court and take the necessary measures at an early stage. In a complex case such as the present, which requires a good deal of evidence before the fraud can be established to the requisite standard of proof, it may be difficult to avoid a full trial. But before I read paragraph 75, that goes to a point my Lord Justice Mayles put to my learned friend, which is here the abuse is established. In many cases where what's relied on is, say, forgery, you need the trial or something like it to establish the forgery itself. But in our case, the finding of abuse is established and no longer open to challenge. Then at paragraph 75, this court said, the judge said at paragraph 150 that he would have struck out all the claims if he was dealing solely with the misconduct of Mr. Massoud. As we have said, we think it was too late to take that course, but the judge was wrong to hold that the fact the defendants had also been guilty of misconduct was a reason for him not to exercise the power to strike out the claims on the grounds of Mr. Massoud's misconduct.
What happens if both the claimant and the defendant have acted in such a way as to forfeit respectively the right to have their claim determined and the right to have their defence considered?
Yes. But it does also illustrate, we would suggest, that, and that point is made over the page, that when the court is considering what sanction to impose for the claimant's misconduct, one doesn't weigh that against the defendant's misconduct. One asks, is the claimant's misconduct of such a nature as to engage the forfeiture principle? If the answer is yes, then that's that, whatever consequences that may have. I mean, if we just look over the page, where the learned judge, this court says, in our judgment, the defendant's misconduct was irrelevant on the assumption that it was not too late to consider striking out the claim. The sole question was whether by reason of Mr. Massoud's forgeries and fraudulent evidence, the claimants had forfeited the right to have an adjudication of their claims. The answer to that question did not involve an exercise of weighing the misconduct of the claimants against that of the defendants. The defendants did not start the proceedings, they were secretly from the court.
There is some difference between our case and this case. In Massoud, both parties were forging documents or destroying documents, whatever it was, which necessarily had an impact on the proceedings, whereas in our case, the allegation is against your side is not to do with misconduct in the proceedings as such, but substantive fraud.
That's true, my lord.
I don't know if that makes any difference, but it's a difference to some extent.
Yeah. That is true. So this is certainly concerned with litigation misconduct, as it were. But it is at least authority for the proposition that if the claimant's litigation misconduct is of such a nature as to engage the forfeiture principle, one doesn't weigh that against the defendant's litigation misconduct. But one then has to ask, why is there no such process of weighing the claimant's misconduct against the defendant's litigation misconduct? The answer we would respectfully suggest is the words which are emphasized by this court in the third line on page 466 in italics. The question was whether by reason of Mr. Masood's forgeries and fraudulent evidence, the claimants had forfeited the right. In other words, one's asking if the claimant, and in a different case, it could be just the defendant, so it's not, as it were, a claimant-specific point, but if a litigant has engaged in misconduct, which engages the forfeiture principle, what the court is asking is, what is the right response to that misconduct, which is capable of preserving the integrity of the administration of justice? And as we read this passage, what it is saying is, the answer to that can't turn on weighing it against the defendant's litigation misconduct. And it's not obvious to us why the analysis should change if the misconduct alleged against the defendant doesn't concern the litigation, but something predating it.
You're calling it the forfeiture principle. Now, there are obviously areas of law where something is lost automatically as a consequence of certain prior acts. We will often refer to that as forfeiture, leases, etc. If in truth this is something akin to a sanction, a response to behaviour, then ordinarily you would require a proportionality analysis, wouldn't you?
Yeah.
And at the moment I struggle to identify another context in which you conduct that proportionality analysis, but ignoring what happened in relation to the other party.
I see what your lordship means, and the answer in our submission is this. It lies in part in a terminological problem in the use of the word sanction, because that immediately makes one think of a penalty, something that's a penalty for wrongdoing or some discreditable conduct. And as your lordship says, when penalties are imposed in various procedural contexts, the court has regard to all the circumstances. But in truth, and I'll show the court this in Aeronominis, which I was going to go to next, what is, perhaps for convenience, described as a sanction for an abusive process isn't actually a sanction. What it is a response by the court, such response as is necessary to preserve the integrity of the administration of justice. Now, if the claimant's misconduct has risen to a point in the scale that allowing them to continue the claim would itself bring the administration of justice into disrepute, then the question of proportionality is answered by that finding, because the only response which is capable of preventing what the abuse doctrine is concerned with is strikeout. And there are different ways to test whether it gets to that point. And there's some assistance on this in Aeronominis, if I can show the court that. Aeronominis, which we have looked at, it's in the same volume at tab 7. If I could invite the court, please, to go to page 144. The judgment of Lord Justice Ward. Paragraph 73 says this: the attempted perversion of justice is the very antithesis of the parties coming before the court on an equal footing. This matter has become hugely more expensive to an extent we did not appreciate. The judge commented at the beginning of his judgment, the hearing has run for 29 days, greatly exceeding the party's estimate. The original estimate was 3 weeks. We were told for another week to 10 days would be required to permit it. The judge did not, however, treat cost and time as elements of the overriding objective. He did not appear to allot to the case an appropriate share of the court's resources while taking into account the need to manage it. And a similar point is made at para 74 and 75 at page 145, where Lord Justice Ward says this was a flagrant and continuing affront to the court. Striking out is not a disproportionate remedy for such an abuse, even when the petitioners lose so much of the fruits of their labor. And just pausing there, I made the submission yesterday when I responded to my learned friend's appeal. What this court is striking out is a petition which is capable of a fair trial in the narrow sense on the findings of the judge below. And what the court is saying is you can have a fair trial, you have, on this hypothesis, an arguable claim, but it is being struck out, and that's not disproportionate, because your misconduct has risen to a level that it is a flagrant and continuing affront. And then 75 says, if the CPR are to receive a correct start, then this court must make the clear statement that deception of this scale and magnitude will result in a party's forfeiting his right to continue to be heard.
Yes, I mean, it is interesting to follow the fate of our nominees. Like those first instance judges, I have been through the rite of passage of a failed arrow nominee's strikeout application. But the consequence is, isn't it, that the party whose claim is forfeited, that their Article 6 right, and indeed if they have an economic asset in the form of the claim A1, P1 rights, are interfered with by a public authority. Now, there are many good reasons why that might be done, but generally, proportionality is a relevant element to the test about whether that is appropriate.
Yes, because what your lordship means, I think, is where the arrow nominees principle is successfully invoked, the consequence is to drive the claimant from the judgment seat, and that infringes their right of access.
And depending upon, assuming they can't bring their claim elsewhere,
potentially
deprive them of the economic asset.
Indeed so, indeed. But there's an answer to that point, both in a judgment of this court and in the Van Hoek-Stratton case, which is that it's been established for many years that if a claim is struck out on the ground that it is an abusive process as a matter of English law, it is by definition not an infringement either of Article 6.
No, I see that. It's just a question of whether that necessarily the exercise in determining whether you should do it must involve a proportionality analysis.
But the way I put it is the proportionality analysis is baked into the threshold. If I persuade your lordships that what you have before you is a case in which somebody has sought deliberately to subvert the process they have purported to invoke, the court isn't, and this is the point Lord Reed makes in the next authority is going to go to, the court isn't imposing a penalty, the court isn't driving the claimant from the judgment seat, the court is drawing an inference that the litigant has only purported to invoke the process because they have evinced an intention to cheat it or to subvert it. Now, I think your lordship, when you refer to the first instance authority, I think the point has been made, including the judgment of your lordship, that it's rare for the arrow nominees principle successfully to be invoked, and I absolutely accept that. But in some cases, of which this is one in our submission, where somebody sets out deliberately to subvert the administration of justice, that is a case for the application of the arrow nominees principle, particularly if the strikeout application is made at an early stage, because one of the purposes of the arrow nominees principle, as Lord Justice Ward and indeed Masood say, is to prevent the allotment of further judicial resources to a litigant who has conducted themselves in this way. But I
mean, that of itself, I mean, I absolutely see, and I see the wider interest of justice test and so forth. But if you manage to prevent your wrongdoing becoming known about until a sufficiently late stage in the litigation, the idea that the prospects of being struck out improve in your favour as a result is not a wholly easy idea.
That, if I may say, is a very fair point. But in a sense, it goes to a deeper point. And I was thinking about it last evening. The example that occurred to me is this, because the questions the court put to me yesterday was, my Lord Justice Phillips asked me, how is this different from what happened in the Mozambique case, or the deliberate suppression of disclosable documents? And the court also asked me about perjury. The difference is, now those things obviously also corrupt the forensic process, and many of the adjectives we are using could be used in those cases. But the difference is this. Although lying to the court or deliberately advancing a false claim is a serious abuse, in some cases, it may be possible to preserve the integrity of the administration of justice by exposing the lie and dismissing the claim. Indeed, that may be a more effective way of preserving the integrity of the administration of justice, which is why the paradox implicit in the point my Lord Justice Foxton put to me, may not in truth be a paradox. Namely, if you hide your forgery until a very late stage, true it is that an arrow nominee strikeout may fail, but you'll lose at trial and you'll be exposed as a fraudster. The best example of this may be, there was a hard-fought trial in the Chancery Division, I think a couple of years ago, before Mr. Justice Meller, where Dr. Craig Wright claimed that he is Satoshi Nakamoto, the person who invented Bitcoin. Now, Mr. Justice Meller's judgment finds that the claim was deliberately false, founded on forgery on an industrial scale, and that Dr. Wright repeatedly lied in the witness box. It might be thought to be a classic arrow nominees type case, but he didn't strike out the claim. What he did instead was, after a trial in the ordinary way, at the conclusion of it, he orally declared that Dr. Wright had brought a fraudulent claim, is not Satoshi, and then produced a detailed judgment taking apart the forgery. Now, one might
think... That's exactly the facts of Masood, isn't it? Masood is a claim based on forged documents, false written and oral evidence.
Yes. And exactly, but what this court was saying was because the strikeout had been brought at trial, it was too late to invoke the arrow nominees principle and to strike it out. But had the strikeout application been made at an earlier date and the forgery is established, an appropriate response might have been to strike out the claim.
Well, the problem sometimes may be that you cannot establish the forgery or the fraud or whatever it is until you've had a trial, because it's not patent on the face of things. We don't have that problem in this case because we know what Black Q did. Although we won't know without either a trial or a summary judgment application whether there is a good claim against your clients.
Indeed, if I may say that if I may say is an important point, which is in our case the abuse has already been established, because I respectfully agree that in cases where somebody tries to invoke the arrow nominees principle, they will in practice be unable to do so because all they'll have is an allegation of forgery. But the point I was making in answer to my Lord Justice Phillips is that the underlying principle is the same in all of these cases. What response from the court is required to preserve the integrity of the administration of justice? But in the application of that principle, there is a difference between forgery cases on the one hand and cases of this kind on the other, because in the forgery cases, the integrity of the administration of justice may actually be better preserved by doing what Mr. Justice Meller did. And that is in part because, although lying to the court is a very bad thing and a serious abuse, it is part of the adjudicative function to distinguish truth from lies.
This is why I find this really difficult, because surely you're relying on Masood, and that's exactly what Masood says, is that because the claim was based on forgeries, the court of appeal is saying it would have been right to strike it out.
At an early stage.
Yes.
At an early stage, but not necessarily at trial.
Yes, but you're saying, as I understand it, there's a distinction between forgery and the type of action in this case.
I'm saying there may be, my lord, because all I'm saying is in forgery cases as well, there may well be cases where the only appropriate thing to do is to strike it out at an early stage. But in some cases, and I gave the Craig Wright case as an example, there may be a better way to preserve the integrity of the administration of justice. But the important point we would suggest is it is no part of the adjudicative function to resolve a satellite dispute arising out of something like the murder of an opposing party or a deliberate invasion of privilege. So if, for instance, the only way the court can decide whether you can have a fair trial is by devoting 6 days of commercial court time plus 2.5 days pre-reading to work out the consequences of abusive conduct, which takes the form of murdering a party or trying to bribe a judge or a deliberate breach of privilege, that is a powerful indication in our submission that the forfeiture principle is engaged. Because by contrast to the Craig Wright type case, where it is in a broad sense part of the adjudicative purpose to distinguish truth from lies, it is in no sense part of the court's purpose or the proper allocation of judicial resources to devote resources of that scale to work out the consequences of conduct that is designed to subvert the system which the claimant has purported to invoke.
Forgive me, I just don't think the authorities you've shown us so far anyway come anywhere close to supporting that proposition. And what Masood is saying, as I understand it, is if a claim, the claim itself is an abuse of process, because it's basically a false claim based on forged documents, false evidence, etc., then you forfeited the right to have that claim tried. Well, that doesn't seem to be terribly surprising if the entire claim is false and fraudulent. And it's no answer to that to say, well, yes, their defence is false and fraudulent too. Now, that says nothing about the sort of collateral abuse that you're relying upon here. And it certainly doesn't say anything about, well, if you're going to need to have hearings about collateral matters, that is a reason for striking out the claim. What this is saying is that at an early stage, you can see that the claim is false and fraudulent. Strike it out then.
Yes. So when your lordship says it's collateral, I mean that, if I may say, one needs to unpack what that means, because
well, here the claim was fully pleaded and formed before any of this happened.
But equally, in our nominees, the petitioner may have had a claim which would have succeeded, despite the lies.
But it was relying on forged documents.
Yes, but
from the start.
Indeed, but they may have had a good, and that's the whole point about this doctrine. You may have a claim which would succeed, which would have succeeded despite the forgery, but that is irrelevant to the question of sanction. And that in a way, is a key point.
So what it's saying, if the claim is abusive in whole or in part because it's based on fraud or forgery, you can strike it out.
Well, but if we test that against the actual facts of our nominees, the unfair prejudice petition, your lordships will recall, was founded on 3 different pleaded allegations, 2 relating to the May 1994 oral agreement, and the 3rd relating to things that the black-ledge respondents had allegedly done in their capacity as directors. The 3rd was entirely uninfected, uncontaminated by the alleged forgery.
Well, by definition, there must be some claim which is capable of succeeding, otherwise you wouldn't be having the argument.
No, but true. But the point I'm making is, what is the rationale, one has to ask, for striking out that bit of the petition? Because that bit of the petition is not a false claim, it's not based on forged documents. That's struck out because by bringing forward a claim which is based deliberately on subverting the course of justice, you forfeit the right to litigate. If that's the right analysis, we would submit Van Hoek-Stratton is the same, and this case is the same. But, yes.
I think this may be a different way of formulating what you were putting. I was sitting in some costs appeals recently, and a judge, I think, of this court makes the point that lies are told in courts up and down the country every day of the week, as it were, in the context of, doesn't mean we deprive everyone of their costs, but in a sense, the idea your opponent's witnesses might be lying is baked in to how you interact with them, and as part of the judicial function, the idea that a witness might be lying is similarly something that one has to keep in mind at all times. And so, in a sense, we're on our guard for those possibilities, perhaps that we're better prepared to meet them. There are tools better able to meet them. The idea that your lawyer has been subverted is perhaps not something, to date at least, that we have had to conduct our litigation strategy on the basis that it might be happening. And similarly, from the judicial function, the idea that it might have happened is not something that you're alive to and need to allow for as a serious possibility in any litigation.
Precisely so. We respectfully agree. I mean, that's, I think, a clearer way of putting what I was trying to put. But it's actually reflected in paragraph 32 of Van Hoek-Stratton, which happily is in the same volume, if I can quickly show your lordships that. It's,
I suppose one could say that the administration of justice relies on the integrity of lawyers in a way that it doesn't rely on the integrity of witnesses.
Precisely so. And that's why, when, in response to my Lord's question yesterday, I accepted it's lawyer-centric. But in a way that understates it. It's not lawyer-centric in the sense that this is about doing something good for lawyers. It is lawyer-centric in the sense that if the system cannot trust the integrity of the solicitor-client relationship which will not deliberately be corrupted or attempted to be corrupted, then the system isn't going to work because it is an essential element of the system. And that's why I would respectfully agree that there is a difference between this form of misconduct or the form of misconduct in Van Hoogstraten and other things that one looks at. And it may be, my lords, that there's more than one rationale for the error nominees principle. One rationale is not allocating disproportionate judicial resources to somebody who set out deliberately to subvert the process. So that's why, as my Lord Justice Phillips, with respect, rightly pointed out to me, it makes a difference whether you bring the strikeout application at an early stage or at a late stage. Because if you brought it at a late stage, that rationale has run out, as it were. But there's also another rationale, and in some cases they will march in step, which is what is it that the court needs to do to preserve the integrity of its process and maintain public confidence in the civil justice system. If we go for a moment to paragraph 32 of Van Hoogstraten, that's tab 16, page 372. What Mr. Justice Lightman says is that the second ground is that the conduct of Mr. Van Hoogstraten is such a flagrant abuse of process and such a challenge to the administration of justice that, irrespective of whether a fair trial is possible, an order to this effect is required in the interests of the administration of justice. No greater challenge to the administration of justice and no greater perversion of the course of justice can be conceived than the murder of the opposing party to gain an advantage in the litigation. It is conduct which no court, with its necessary concern for the administration of justice, can tolerate. Such an order is both proportionate, I'd underline that word, and necessary. And then, if we just look at 33, about 4 lines, the learned judge says, I've had in mind that an order of striking out is of last resort, the need to balance the personal right of Mr. Van Hoogstraten against the personal rights of the claimant. But then he says, I have no doubt that on the facts of this case, the intrinsic justice requires the making of the order sought, and the order sought is the only proper result for the reasons I have given. Now, both below and in this court, a point was made against me. Well, murder is different from privilege hunting. Van Hoogstraten is an extreme case. But one's got to analyze what is the principle underlying paragraph 32. It can't be that the fairness of a trial is jeopardized, because this is a separate ground which assumes that a fair trial is possible. The learned judge says only one sanction is appropriate, even taking into account proportionality, Article 6, right of access. So one then has to ask, why is the learned judge saying that? And we would respectfully submit the answer is what my Lord Justice Mayles put to me, which is there are certain things that are taken for granted when you choose to litigate in the English courts. And one of those is you will not murder your opponent. You will not deliberately seek to corrupt the solicitor-client relationship. And there may be a very small number of other things. You won't attempt to bribe the judge. I mean, the idea that if somebody bribes a judge at a CMC, that there should be an investigation of whether a different disclosure order would have been made and what impact that would have had on the outcome of the trial is, with respect, not an attractive one. But that is the conclusion to which my learned friend's argument would lead or could lead. Whereas on our case, if you seek to bribe a judge, game over. That's not how English litigation works. Now, in the interest of time, I hope your lordships will forgive me if I don't go to the Lord Reed lecture, but I would, if I may, give you a reference.
Just give me the reference.
Of course, yes. It's at volume 5, I know. Just quick to look at it. It's volume 5, tab 61.
Thank you.
And just very quickly, what Lord Reed does is he identifies...
I mean, it's several pages. What's the particular bit that you're interested in?
Perhaps I should just take your lordship to it. It might be better. Let me do that. So if we pick it up first at page 2017. Lord Reed says, this is the final paragraph on the page, what I propose to discuss is how the courts deal with litigants who set out to deceive the court and so on. And then in the final bit of that paragraph, he says, where on the other hand it's established prior to proof, I think that means prior to trial in our English terminology, prior to proof, possibly as the result of an admission or a preliminary proof, or where it becomes apparent during the proof that one of the parties is seeking to subvert the process of the court by fraudulent means, the court has to decide whether the case should be allowed to proceed any further. It has essentially two choices. It can decide to carry on, notwithstanding the party's efforts to subvert the court process and do the best it can in the circumstances, or it can decide to dismiss the party's case there and then. Then over the page, Lord Reed notes that the English cases identify more than one approach. That's the second line. Then he says 4 approaches can be discerned. I won't read that out, but he identifies what the 4 approaches are. Perhaps you should just look at that. First is contempt. Second is that you forfeit your right to have the court hear your case. The third is the court should simply carry on and adjudicate on the issues. And the fourth brings into bear the overriding objective of the CPR, the allotment of proportional judicial resources and so on. Then at page 2028, Lord Reed discusses arrow nominees, which we've looked at, and the Summers case as well. And then we rely on his conclusion at page 2032, having discussed those cases. He says, at the bottom of page 2032, in conclusion, I would suggest that judges should not be unduly reluctant to dismiss cases where it appears that the litigant is determined to subvert the adjudicative process by fraudulent means, if the courts wish to avoid bringing the administration of justice into disrepute. They should, in my view, be slow to make decisions favoring those who set out to use the court process as an instrument of fraud. Summary dismissal in such circumstances is not, to my mind, aptly regarded simply as the denial of a right of access to the court, which is the point we were discussing, where a litigant has demonstrated that his object is to prevent a fair trial, and that's the effect of the learned judge's finding in this case. He is merely purporting to invoke his right of access to the court. His real object is not to have a fair trial at all. And that's where I got the language of inference from. So those are the passages on which we rely.
Thank you.
That's all I wanted to say about the second of my 7 points. I was going to move on to point 3, which in some respects is a simpler point. It concerns the need for deterrence. And we've got 3 propositions about deterrence, one of which may be common ground. I'm not sure if it is, but we'll see. Proposition 1 is that the sanction for any form of abuse, I mean, whether the form we are concerned with or anything else, must be capable of deterring other litigants from the same abusive conduct. That's part of the function of a sanction. I continue to use that word, even though it's not the best terminology. The learned judge preferred the word response, which may be better, but that's a terminology point. Proposition 2, deterrence is of particular importance in relation to the form of abuse with which we are concerned, namely privilege hunting. Proposition 3 is that nothing short of strikeout is capable of achieving the objective of deterrence, although in advancing that proposition, I need to address the alternative that my Lord Justice Foxton identified yesterday of discharging the freezing order. But those are the 3 propositions. As to proposition 1, I'm not sure if this is common ground or disputed, but we say that as a matter of principle, a sanction for any abusive process must not only protect the court's process in the particular instance, but be capable of deterring other litigants from the same abusive conduct. And there is in this context an analogy with the law relating to the consequences of a failure to give full and frank disclosure. Such a failure is not of itself an abusive process. You need something more. But even in that context, it's well established that the choice of sanction for a breach of that duty has a deterrent element in the sense that the court's response must be capable of deterring others from breaching that duty. Again, I hope your lordships will forgive me for just giving you a reference, but the authority for that proposition is the Mould Investments case, Authorities Volume 3, tab 46, page 1385, paragraph 152 in the judgment of Lord Justice Nugent. He says there's a deterrent element. Now, we say that if a sanction for a failure to give full and frank disclosure has a deterrent element, then so too must a sanction for an abuse of process, which will often be more serious than, say, an innocent failure to give full and frank disclosure. The learned judge appears to have accepted this at paragraph 52 of his judgment, that's Co-Bundle, tab 8, page 129. Where he says that even if not containing a penal element, the court's response may involve a deterrent factor, which we would respectfully suggest somewhat understates the position, as the true principle is that a sanction for abuse must, not may, be capable of deterring others from the same conduct. And to the extent the learned judge was saying that that's not a requirement, we would suggest that that's an error of law. One wouldn't say that, for instance, in the context of a failure to give full and frank disclosure. One would say, I'm concerned with demonstrating both to this litigant and to other litigants that this is not to happen. And it's the same principle that applies in our context. So that's proposition 1. Proposition 2 is that deterrence is of particular importance in relation to this form of abuse. That is because, my lords, privilege hunting, whether it's successful in a particular case or not, is capable of undermining the most basic public policy behind legal professional privilege. That purpose or policy is described in various places. Conveniently, we can take it from the Adil C case, which is Authorities Volume 2, tab 28, page 696. The case concerned an interesting issue. It was whether is privilege in solicitor-client communications lost if the client company is dissolved and ceases to exist. The argument was it must be, because there's nobody who's capable of waiving it, nobody who's capable of asserting the privilege. But this court rejected that contention. If we go to page 703, please, in the judgment of Lord Justice Lewison, there is a heading called the rationale for legal advice privilege. At para 7, there is a well-known passage from the Derby Magistrates Court case that is quoted, which says that the principle which runs through all these cases and the many other cases which we have cited is that a man must be able to consult his lawyer in confidence, since otherwise he might hold back half the truth. The client must be sure that what he tells his lawyer in confidence will never be revealed without his consent. And a similar point is made by Lord Justice Lewison himself at para 29, that's page 707. All the statements I have quoted suggest that privilege attaches to communications at the time when they were made, and that the privilege remains unless and until the client consents to its waiver. The rationale for the privilege means that privilege comes into existence at the time when the person consults his lawyer. The client must be sure at the time when he consults his lawyer that without his consent there are no circumstances in which the privileged communications will be disclosed without his consent. I don't think that of itself is controversial. That's the rationale for legal professional privilege. But the reason why it matters in our case is it goes to show that privilege is fundamental to the way our legal system works. And leaving aside the Nigeria case, what the claimants have done in this case appears to be unprecedented, a deliberate attempt to breach privilege. But if it were to become more common, as it might, absent an effective deterrent. Query what that is, I'll come back to that. But absent an effective deterrent, if it were to become more common, then lawyers would likely have to advise clients to be careful in what they say, because it is possible that the other side may steal or seek otherwise improperly to obtain privileged communications. But that, in my respectful submission, will be contrary to the purpose of privilege, which is to avoid precisely that. Now, my learned friend's answer to this point, at paras 76 to 77 of the skeleton, I don't think we need to turn it out, they say this is all a false alarm, a false point, because you can trust the lawyer to comply with their professional duties and not succumb to what Black Cube did in this case. So that's their case. And there are two reasons why we respectfully submit that is not a satisfactory answer to this point. First, it overlooks the fact that privilege hunting could occur without any wrongdoing by the solicitor. For example, where their email account is hacked or where they are threatened with violence, which would not involve any breach of professional obligations on their part, as distinct from a case where they are bribed to part with privileged information, which would. But the conduct that falls to be deterred is privilege hunting, not the means by which it occurs in an individual case. And it would, in our respectful submission, be surprising if the law were to take the position that privilege hunting by hacking or threats of violence requires deterrence, but that privilege hunting by bribery or fraudulent misrepresentation does not, because the solicitor can be relied upon to comply with their professional obligations. That's unlikely to be a coherent position for the law to adopt. So that's the first reason why my learned friend's argument, we say, doesn't work. The second is a more general point, which is the fact that some conduct is preventable by other means doesn't mean that it doesn't need to be deterred. I mean, to take a simple example, people can no doubt buy a home camera or a sophisticated alarm system, but nobody would suggest that that means that there's no need to deter robbery. Similarly, it is true that if a litigant, in a case of this kind where a very large sum of money is at stake and it's hard fought, if a litigant offers the opposing solicitor a bribe of $20 million to part with privileged information, may well be what Mr. Howard KC in Nigeria, I believe, described as a life-changing sum of money for the individual involved, and they succumb to that, they would no doubt be guilty of serious misconduct if they were to take the bribe and provide the information. But that doesn't mean that there's no need to deter the offer of the bribe. That's the thing that the law is deterring, or should, in our submission, seek to deter. So that is proposition 2, that this is a particular form of abuse for which deterrence is important. If we're right about that, we then get into the question of what sanction is capable of achieving that objective. That's proposition 3. And perhaps the way to test this, my lord, is first by identifying all the possibilities and then just working through them. As we understand it, what's on the table is 1, an award of indemnity costs; 2, striking out the summary judgment application; 3, the discharge of the freezer; 4, the exclusion of the Black Cube evidence.
A discharge of freezer carrying with it the potential for the enforcement of the undertaking.
Precisely. So no, that's a very important point, indeed. 4, the exclusion of the Black Cube evidence. And 5, restraining the current legal team from acting. I don't understand any further possibility to have been identified. That seems to be what's on the menu, as it were. Now, so far as indemnity costs are concerned, your lordships have the point. In litigation of this scale, it doesn't move the dial. Indeed, an unscrupulous litigant, and ex hypothesi, that's what we're dealing with in any privilege hunting case, may actually regard privileged material in exchange for indemnity costs as rather a good deal. Similarly, my lords, striking out a summary judgment application could not achieve the objective of deterrence in our submission, because in some privilege hunting cases, there will be no summary judgment application, because it would just not have been made. And even if there were, it might again be regarded by a litigant as a pretty good deal.
Now, at the moment, these submissions are proceeding upon the basis that there must be a single response for all types of privilege hunting case. There'll be privilege hunting cases without freezing injunctions. Is that a correct way to approach it, or is the correct way to approach it to say what would be an appropriate sanction in this case that might not rule out the possibility of a different sanction in another case where there might be fewer levers available?
No, that's fair. I mean, it's not right to approach it as if these sanctions are hermetically sealed. Indeed, the learned judge himself imposed two of them, not just one, indemnity costs and summary judgment. But my answer to that is this. Let's park for a moment the discharge of the freezing order, which I'll come back to, because I would accept that has a better prospect of achieving deterrence than the other sanctions, although we still say not enough. But let's park that for now. We say the other things on the menu, whether individually or in combination, are not capable of achieving it. I mean, you could do all of it. Indemnity costs, strike out a summary judgment, exclude the black cube evidence, restrain the current legal team from acting. But even if the court did that, privilege hunting might be seen by litigants as a game with upside and no downside. Because all that happens is if you go privilege hunting and you don't get caught, then you have the benefit of the privileged information throughout the life of the claim. If you get caught on this hypothesis, all that happens is, and I don't say all in a tendentious way, but all that happens on what we are now discussing is, you've got to pay up indemnity costs, you can't rely on the material obtained through privilege hunting, you may have to replace your lawyers, and you've got to go to trial because you can't get summary judgment. But that may well be regarded by somebody as a game with upside and no downside, because you're not worse off except for the need to change your lawyers, but in litigation of this size, those costs would not be material. Exclusion of the evidence, you're not worse off than you were before you started privilege hunting. You're still where you were before you embarked on this exercise. It's simply that you're not better off. So we do say that all of these other possibilities, whether individually or in combination, are not capable of achieving the objective of deterrence. Indeed, my lord, it may be the point goes further than that. It's not just not capable of achieving the objective of deterrence. Imposing inadequate sanctions could have the opposite effect, and that's a point made in a recent authority, of incentivizing privilege hunting, especially if it's a judgment of this court or the Supreme Court, which sets precedent, because then litigants who look at it form the view, this is what will happen to me if I go privilege hunting, and that's a pretty good deal for me. The case I had in mind is not about privilege hunting, but about sanctions more generally, is the Southampton Football Club case. What happened was pretty recent. I think Southampton were due to play Middlesbrough last month in the Championship playoff final. A game which I understand to be worth 150 to 200 million pounds because of the possibility of promotion.
The highest value game in football.
Single game, yeah. 2 days before the game, on the Thursday, a Southampton employee went to the Middlesbrough training ground, positioned himself behind a tree, and took a video of the Middlesbrough training session. But he was caught, but not before he sent the video to the Southampton coaching staff, including the manager. A disciplinary commission of the English Football League sanctioned Southampton by expelling them from the playoff final. And Southampton appealed on the ground that the sanction was disproportionate, and the appeal was dismissed by a former Lord Justice of Appeals, Gary Hickenbottom. It said supplemental authorities, tab 5, page 203.
What's the legal status of this?
It's an arbitral award. I just rely on it as Sir Gary's analysis of how the effectiveness of sanctions. It's at page 203 of the supplemental authorities. I mean, I suppose it's a bit like an ICSID arbitral award, which is sometimes published and cited. I don't put it higher than that.
Yes. Well, you're just really relying on the reasoning as
Persuasive, if your
a
lordship.
submission that you're wanting to adopt.
Indeed, yeah. It's page 228. Subparagraph 4. The Commission in this case expressly considered whether a lesser sanction than that which they imposed would be appropriate. I deal with the issue of proportionality specifically below. However, the Commission expressly considered that a mere financial penalty would not only be ineffective as a sanction, but rather perversely, such a penalty may act as an incentive for clubs to breach Regulation 127 and pay the fine in an effort to increase the chance of promotion. That analysis, which would equally apply to any non-sporting sanction, is unimpeachable. So I only rely on that so far as it goes in support of the submission that imposing an inadequate sanction may actually do more harm than good, because until the claimants did this, certainly I've never heard of anything like this, where you deliberately seek to get a privileged document. Certainly before the Nigeria case, I very much doubt that that was something that members of the bar even considered was a possibility. Now people know it is. If the sanction isn't adequate, that's then worse than things were before.
I mean, is it that different from bin man hoovering up waste outside barristers' chambers and solicitors' offices, which was a known hazard at one point?
Yes, and I needed to deal with the Hamilton case, which I think is what your lordship had in mind. But 2 points on that. First, we can go to it if we need to.
Well, I'll just say before you deal with that, I allowed that bundle in.
Yes.
Since, despite objection, because we rely on counsel only to cite authorities which are really going to help us. But I have to say I've yet to be persuaded that there's anything really useful in it, which we wouldn't otherwise have regarded as pretty obvious.
I apologize for that, my lord. It may be the Merrin Meat case is of some assistance in relation to...
Right, well, if we get to another one which is helpful, then I'll take it back.
No. And I'm sorry it was late. It's simply we identified some authorities and we're preparing for the appeal, but I'm sorry about that. On Hamilton, 2 very quick points, and I'll come back to it. First, the person who bought the papers was not Mr. Al-Fayed himself, but Mr. McNamara, his agent. No finding of fact that Mr. Al-Fayed intended to get privileged documents, nor even a finding of fact that Mr. McNamara intended it. That's the first point. So it's not actually a case of privilege hunting. It's a case in which, a bit like Rakia when we come on to it, you do something else and it turns out that the stuff you've got is privileged. But that's different from seeking deliberately to obtain privileged information, which happened in the Nigeria case, of deliberate retention. Second point, Hamilton is cited and distinguished Nigeria itself, where the court makes the point that it wasn't a strikeout for abuse, it was an application for a fresh trial with invoking the nominees principle to debar defending the new claim. So it doesn't deal with issues that are now before your lordship.
I was more, I think, I'm not sure the idea that unscrupulous people might seek to subvert privileges, at least based on my own professional experience, quite as novel as you might be suggesting. It doesn't make it anything in any way less worthy of condemnation. But, I can quite see involves a scale of professionalism in those who are doing it, which certainly does appear to be a very novel feature.
Yes, no, I certainly defer to your lordship on that. But that's our point on deterrence. Nothing other than, I'll come to the discharge of the freezer, but nothing else, whether individually or combination, is really going to move the dial. So that takes us then to the question of the discharge of the freezer. And I accept that by contrast to the other sanctions, that is likely to be seen as a real disadvantage by claimants, especially if the cross-undertaking is also capable of enforcement. So it will probably have some deterrent impact. It's the sanction chosen by Mr. Voss QC in the Merrin Meat case. But there are 2 reasons why we say that it doesn't go far enough in achieving that objective. The first is a point my lord identified a few minutes ago, which is that there will be cases where privilege hunting occurs in which there's no freezing order at all. Indeed, I venture to suggest that this sanction will in practice only be available in fraud claims because it is customary. I mean, typically you get freezing orders only in fraud claims. I mean, you could do it in non-fraud claims, but it's more common in fraud claims. So if one then posits a case where there's a 1 billion or 2 billion shipping dispute or banking dispute or reinsurance dispute, bet the company litigation, say like the Catalyst case, two private equity firms have fallen out and are fighting about very large sums of money. One may take the view that if this is the sanction that the court imposed in that case and it rejected strikeout as an appropriate sanction, then I'm not going to get struck out, and anything short of that is fine, I can live with it.
I'm just trying to follow this argument. It's, and I know you don't accept this, but let's say it would be a proportionate response to the conduct in this case to discharge the freezer, but because there might be different cases in which that option wouldn't be available, that means that you're required to strike out this case. We don't generally, I think, when imposing sanctions, say that because there might be different cases with different facts where that sanction wouldn't be appropriate, we're not going to impose it in a case in which it would be, because of the risk of it not deterring. At the moment, I don't find that an easy argument.
No, I mean, that is fair in the sense that the mere fact that a particular sanction might not work in some other case can't be a reason to impose a different sanction in this case. But I don't think I'm going that far. All I'm submitting is one of the factors that your lordships will need to take into account if and when you re-exercise the discretion is what sanction is capable of achieving the objective of deterrence in cases of this kind. And when I say cases of this kind, what I mean is extremely high value, hard fought, bet the company, fraud litigation, or some other litigation of that kind, in which people will literally stop at nothing to win. Indeed, that must be the premise of our analysis, because we only get to sanction if privilege hunting has occurred, and privilege hunting has occurred, then that's a pretty good indication of what the litigant is prepared to do. So while I accept that this is not, as it were, a trump card, in the sense I can't get home on strikeout simply by saying that nothing else is going to cut it, if your lordships were to accept my submission that the discharge of the freezer will not send the message that this judgment will need to send in order to achieve the objective of deterrence, then that is an important factor. I don't put it higher than that.
There's been some reference to whether the claimant's undertaking could be enforced in addition to discharging the freezing order. Have we got the terms of the undertaking?
Can I check that? I don't believe it's in the core bundle.
Because if they're in the standard term, which, as I recollect, is something along the lines of, if it turns out that the freezing order ought not to have been granted, then comply with any order the court may make, something along those lines. It would face the problem, or any application to enforce it would face the problem that when the freezing order was granted, it was perfectly in order for it to be granted. It's only later, because of the claimant's later conduct, that the court has decided that it ought no longer to be there. So there might be issues around that, and one might need to look quite carefully at exactly what the terms of the undertaking were, which, as I say, I don't think we've got.
I look at the wording, my lord, but I see what your lordship means. I suppose this thinking aloud, one way around it, if your lordships are against me on my primary case, which is strikeout, and you were minded to discharge the freezing order, but it seems that the enforcement of the undertaking may present problems, I can't see any reason why your lordships could not say claim will be struck out unless the claimants give a different undertaking in terms which would enable it to be enforced upon the discharge of the freezer. It would take the form of a conditional order. And then they could elect. If they say we won't give the undertaking, they get struck out. Or they elect and then the undertaking is enforced. But I mean, I don't want to sort of...
and there was a separate application to discharge the freezing order as an alternative to strike out.
Yes.
What's happened to that? Was it before the judge?
It was. It was before the judge. It was argued. I'll check the skeleton, but I remember that we set up alternative cases. If we fail on strikeout, the freezing order should be discharged. The learned judge adjourned that application to the information review hearing. I can show you, Lordship.
Oh, I see. It's gone off with that.
It's gone off. But it doesn't seem to us that poses any procedural problem. In re-exercising this question, if your lordships reject my primary case of strikeout, but were to form the view that the discharge of the freezer is the appropriate sanction, there's no reason why this court couldn't simply do that. There was an application before the judge. But even if there weren't, the whole point about re-exercising discretion is this court decides what is the right thing to do.
What is going to happen if you're right about in these hard-fought actions with parties prepared to play dirty, is if we say that this type of conduct leads to claims against fraudsters being struck out, is we're going to get an awful lot of false flag operations.
Yeah.
And it's not unknown, I've come across it in litigation, that defendants witnesses, lawyers say, I've been contacted by somebody from the other side trying to get me to X, Y, or Z. And if we say that if sufficiently proved leads to the complete strikeout of a massive fraud claim against your clients are massively incentivized to obtain their own black cube to go and pretend to be acting for the claimants. I mean, I'm afraid however you cut this one way or another, this will incentivize somebody in one direction or the other.
Oh, I see what your lordship means. Two responses to that, if I may. First is when your lordship says false flag operation, I suppose there are two possibilities. The first is somebody may bring a privilege hunting strikeout application when in fact there's been no privilege hunting at all. They may say somebody spoke to me, they were acting on behalf of the claimants, therefore strike out. But the learned judge says in this judgment, and we agree, that A, you have to prove this on the balance of probabilities, which they probably wouldn't be able to do. It's not like forgery where you need a trial to sort that out.
But as you said, there's a lot to gain here. You're inviting us to make an order which means there's a huge amount to gain. The defendant, banged to rights for a huge fraud, has got a potential complete get out of jail card here. What is to be lost for mounting an operation and trying to blame it on the claimant?
Well, two things. I'm not going to say that won't happen in practice because, as your lordship says, in litigation,
well, using your own logic against
exactly.
You, of course, it's going to happen.
Yeah, but the point is, if it does happen, they will only get the remedy I'm inviting your lordships to grant if they actually prove it was done by the claimants on the balance of probabilities, and they won't be able to do it because it'll. I mean, how will they do it? If they were responsible for it, it's going to take.
Because people lie.
Well,
and they
indeed.
Forge documents. And they do all the things that you're saying will be done by the people who are going to be privilege hunting.
No, indeed.
And
but
it will be done, the privilege hunting will be done, but unbeknown and possibly unprovable. It won't have been done on behalf of the claimant, it will be done at the instigation of defendants. And I'm afraid, without going into too much, I've experienced it in litigation where there have been allegations that one party has sought to pervert the other side or subvert the other side's witnesses.
Yeah.
And the answer to it is, well, it's false flag. Or is it false flag?
Yeah.
And you have a whole battle, a whole satellite litigation on whether this exercise was or was not the claimant, or was it the defendant, or a third party engaged by them.
So I completely understand.
Any absolute rule here that this results in strikeout is going to incentivize parties in either direction, isn't it?
I understand, my lord. Can I give your lordship two very quick responses? First, if this were to happen, presumably when the defendant, having launched this false flag operation, then brings the strikeout in the commercial court or the Chancery Division, the claimant's going to come along and say, it wasn't me. The judge has to decide that. The burden of proof will probably be on the defendant because he's the applicant seeking strikeout. And even if there's satellite litigation and the judge finds this was a false flag operation, that means the defendant advanced a deliberately false case. The strikeout will fail, probably with indemnity costs. But that's my first point. My second point is the other side of the coin of what your lordship's putting to me. If the court were to say that the fact that this is a fraud claim can reduce the sanction, which would otherwise be appropriate for privilege hunting. It sends an equal and opposite message to litigants that you can subvert the court process and you'll avoid strikeout if you're alleging serious wrongdoing by the other side. But it may be I'm simply echoing what your lordship said, which is whichever way one goes, there is a problem. But the difference is, once that finding of fact has been made, as it has been in our case, that the claimant deliberately subverted the system by seeking to breach privilege, we would respectfully suggest that the prospect of false flag operations in the future shouldn't deflect attention from what we know has happened here and might happen in other cases. And indeed,
I'm simply responding to this is your point 3, which is the need for deterrence.
Yeah.
How this is going to work in the real world.
Yes, and the answer I'm giving your lordship is that the prospect of a false flag operation doesn't reduce the need to deter privilege hunting, as it were. Because one doesn't want a world in which privilege hunting becomes more common either. And if one has to...
No, I think the point I'm making is what you have to be careful about is giving people a bullseye or a golden ticket, or however you want to put it, a get out of jail card. What you need to look at is the proportionate response in all the circumstances. Once the full facts are known.
But I query, my lord, with respect, in the false flag operation, it's a very dangerous thing for the defendant to do, because if the false flag is exposed, the Aaron nominees principle will probably result in the defense being struck out, because they've sought deliberately to...
Well, we're talking here about parties who ex hypothesi are banged to rights in a fraud claim. So, as you would put it, there isn't much to lose here. How can they be further penalised for an award for indemnity costs, which will probably be made against them anyway?
Well, it would probably be more than that.
Anyway, it's
but
just a thought.
Your lordship has my submission. So anyway, that's what I wanted to say about deterrence.
I suppose the false flag operations would be even more obviously criminal than what may or may not be the case on the facts of our case, because you would be conspiring in an obviously, even more obviously false way.
Yeah.
Depending perhaps on what jurisdiction you did it in, but you'd certainly be doing it to affect English litigation, so there would be a substantial connection with this country.
Yeah.
So that might be a factor reducing the risk to which my law refers. But on the other hand, if the people doing this are people who pride themselves on their espionage skills, not necessarily black cube, but in another case red cube or purple cube, wherever it may be, perhaps that would not be too much of a disincentive, I don't know.
No, and I would accept that the trouble about a point like deterrence is nobody can really predict the future, what exactly is going to happen. But the way I put it is, this court knows what has happened in this case. It's a very odious thing, and the learned judge said it amounts to cheating the system with a view to undermining the level playing field. I mean, your lordships had the point.
Yes.
So just to finish off on deterrence, our primary case remains strikeout. But if your lordships are against us on that, then our fallback case is discharge of the freezing order. There's no procedural obstacle to the court doing that, coupled with the enforcement of the undertaking, if necessary, by imposing a conditional order. And I'll come back to the court on the wording of the undertaking. Now, that's the third of our 7 points. I'm going to take the fourth one reasonably quickly, if I may. This is authorities on the choice of sanction. The first case is something we've already looked at, which I won't go back to. It's the Nigeria case. I did want to take the court to the Grant case, but there may not be time. Maybe I can give your lordship a reference. It's Authorities, Volume 1, tab 13, page 302. And I can, as it were, encapsulate the point in a minute. Grant is an interesting case because it arises out of a covert operation by, I think it was the Lincolnshire Police, in 3 operations called Operation Mink, Wheel and Galaxy, where they placed a covert listening device in the exercise yard of a prison with the purpose of catching communications between the prisoner and the solicitor. And the exercise yard was chosen because that is where those conversations would take place. The crime with which the accused was charged, or maybe we should just look at it, having said I put it, it's tab 13. So what happened is, just to summarize the facts, these devices picked up conversations between the defendant and the solicitor. All 3 defendants were charged with very serious offenses. I think it was conspiracy to murder in one of these. All 3 defendants made an application to the Crown Court to stay the prosecution. So this is the limb 2 abuse, which we talked about yesterday, which is not based on fairness to the accused, but on the integrity of the criminal justice system. The the abusive process stay application was successful in Wheel and Galaxy, but unsuccessful in Mink, because the trial judge in the Mink case did not find that it was the purpose of the police to catch privileged communication. So there wasn't a finding that that was the subjective purpose. But the judge was overturned by this court on that factual point, and one can see that at paragraph 50 at page 320. Where Lord Justice Laws says that we are satisfied that the defendant has shown, at least on the balance of probability, and that is all that is required, that Operation Mink was infected by the same unlawful purpose as infected Wheel and Galaxy. This court then held that the prosecution was an abuse and should be stayed, even though there was no prejudice to the accused. And the reason there was no prejudice was that although the police put the device in the exercise yard, he didn't pick up any information that was of any use to the prosecution. One can see that in the first sentence of paragraph 53 at page 320. In the present case, it is said there was no prejudice. Nothing was recovered from the illicit intercepts of any value to the prosecution. If we then go over the page, please, this is where Lord Justice Law's reasoning is set out. We have concluded that this is a mistaken approach. True it is that nothing gained from the interception of solicitors' communications was used, however indirectly gave rise to evidence, nor, as we understand it, did the intercepts yield any material which the Crown might deploy to undermine the defence case. But we are in no doubt that, in general, unlawful acts of the kind done in this case, amounting to a deliberate violation of a suspected person's right to legal professional privilege, are so great an affront to the integrity of the justice system, and therefore the rule of law, that the associated prosecution is rendered abusive and ought not to be countenanced by the court. Now, paragraph 55, first sentence, is important because it concerns a point my Lord Justice Phillips asked me about yesterday, where Lord Justice Law says it's not the function of the criminal courts to discipline the police. So that's not what the sanction is doing. And then 57, we are quite clear that deliberate interference with a detained suspect's right to the confidence of privileged communications with the solicitor seriously undermines the rule of law and justifies a stay on grounds of abusive process, notwithstanding the absence of prejudice. Mr. Justice Newman took the same view in Wheel. He had in mind the gravity of the crime with which the defendant was suspected. So, of course, do we in the present case. As for prejudice, it is a particular vice of the police conduct in such circumstances as these, that the court cannot know whether the police misconduct has in fact yielded fruit in the form of evidence, whether directly or indirectly, without inquiry as to what the covert surveillance revealed, but that would further violate the suspect's right to legal professional privilege. Now, in the Warren case, the board said, and we've always accepted this, I think we drew this to the court's attention below. In Warren, the board said that Grant was wrongly decided, but what they meant by that was that this court was not entitled to interfere with the exercise of discretion by Mr. Justice Astor in the Mink case. What they did not say was the reasoning in Grant was wrong. They said that absence of prejudice is not irrelevant, but indeed they said at paragraph 36 of Warren, which we looked at yesterday, that they agreed with Lord Justice Laws, that it will often be an affront to justice, requiring a stay of the most serious criminal prosecution if there's a deliberate interference of privilege.
Is this a real analogy? I mean, on the one hand, in criminal cases, you're concerned with misconduct by agents of the state,
Yeah.
and consequences where a person's liberty is at stake. Conversely, in criminal cases, the question looked at here was whether the exercise yielded fruit in the form of deployable evidence, whereas in a civil case it may be very useful to know what the other side is thinking,
Even
where
if
they see pinch points in
Yeah.
their case and so forth, even if that does not give you anything which you could use as evidence in court. So there are quite
There are.
material differences, it seems to me, between civil and criminal cases.
No, I would certainly accept there are material differences. I suppose the question is, in which direction do those differences point? So on the first of the 2 points your Lordship mentioned, it is of course right that in these cases one is concerned with state misconduct, as in this case it was police misconduct. But it's well established, and we looked at Warren itself yesterday, that the limb 2 abuse jurisdiction in the criminal law, it is not any part of the purpose of that jurisdiction to discipline the police or penalize the state. Its purpose is only to protect the integrity of the criminal justice system and maintain public confidence in it. If I can give your Lordships a reference to that, we haven't got it in the bundle, but Archbold, paragraph 487, at page 336, has a useful summary of the recent Court of Appeal cases on this point, limb 2 abuse, and it says at the bottom of page 336, the purpose of the state in such cases is not to punish or to express the court's disapproval of official conduct. Rather, it's about whether the public would lose confidence in the criminal justice system. And we say you see the same rationale in our nominees. Indeed, the interesting thing about our nominees is I don't think I took the court to it. The person who did the forgeries was Nigel Tobias. But there was a second petitioner, Lorraine Blackledge, who was in the Tobias camp but had not been involved in any wrongdoing. Her petition was also struck out, and the court was pressed with an argument, you can't strike my petition out because I didn't do anything wrong. The court's answer to that was, we are not striking it out as a sanction or penalty. We are doing it because nothing short of it will preserve the integrity of the civil justice system. So it's the same rationale that one has in the 2 cases. But your Lordship's second point I entirely accept, which is in civil cases, there may be a very significant advantage, even if you can't deploy material. But I suppose that, in a sense, increases the severity of privilege hunting in civil cases, as distinct from reducing it. But that's Grant and Warren, and that's really all I want to say about the authorities. Turning then to my 5th point. So the first 4 points I've made are all general about privilege hunting. My 5th point is specific to the facts of this case, because we say that even if in other privilege hunting cases strikeout is not the appropriate sanction, there are serious aggravating factors specific to what the claimants did. The first point concerns the claimant's conduct after they received the recordings from Black Cube. And I'll take this shortly because I made the point when I dealt with the claimant's appeal, that on the claimant's own case, at the point they pressed the play button on their computer, when the recordings come to them, they had no reason to believe that what they were about to listen to would not be privileged. Because the attempt to defeat privilege by invoking the iniquity principle derives only from the content of what X said and doesn't derive from anything independent of that. It follows that the claimants chose to listen to a conversation with the defendant's solicitor about this case, and when they made that choice, they must, even on their own case, have believed that it would probably be a privileged conversation. So, learned judge in our submission was right to say, para 64, that this compounds or aggravates the abuse, and that is a material factor in choosing a sanction. You won't have that in every privilege hunting case. Indeed, if the claimants had listened to Ennio, presumably they would have never seen it.
But if the abuse is commissioning someone to go and hunt for privileged information, is it really the case that there's some separate and aggravating step of then planning to gain the benefits of what you've authorised someone else to go off and do? Or is it that really, those two parts are inextricably linked, and they are what makes this abusive? You're never going to send someone off to do it without intending to avail yourself of the fruits of the work for which you're paying dearly, as we've seen.
Yeah, perhaps the way to put it is it involves not taking advantage of a locus ponitentiae, if one is allowed that terminology.
We don't normally aggravate.
No, but the reason why we say it is an aggravating factor is this. I'm going to go to the authorities in a moment, but there's a body of English case law about the duties of litigants and their solicitors when apparently privileged documents come into their hands. I mean, this actually happens sometimes inadvertently.
Well, that is a white book rule, isn't it? Because that is in the that is in the rules.
Precisely. And I'm going to show your lordship some authority. But what the authorities say is that if you get your hands on apparently privileged communications, even outside the white book, happens in family cases where you take your spouse's documents and you want to use it in litigation, you can't read it. And
I think one of the leading cases were my old chamber's reception sending papers back to the solicitors on the other side, which due course became English and American insurers against others.
I think something similar happened in the Appellant case. Is it somebody at 3DB, if I remember correctly? So yes, I mean, so that's the aggravating factor. But there's an additional aggravating factor here, which is the learned judge has made a factual finding in paragraph 29 that Ennio refused to look at it. Now, when your own solicitors refuse to view the recordings, it is an indication to you, we would suggest, that you ought not to view this stuff. But they did.
So if the claimants, Ennio said, we're not going to look at this because it's prima facie privileged. If the claimants had said, well, we hadn't thought of that, you're absolutely right, we're not going to look at this. In fact, we're going to destroy it all and apologise to X for what we did. Would you still say that then there was an abuse which merited a strikeout?
Yes, I would, but I say that I have a stronger case because it did happen. If your lord, I mean, this all assumes that your lordship's not.
What is the actual sequence? Had the claimants looked at it before giving it to Ennio? Presumably they had, but I don't know if we know that, do we?
I think we can infer it, and the reason I say that is this. At paragraph 34, the learned judge found that the black cube evidence informed their negotiating position in without prejudice discussions. There is unchallenged evidence in paragraph 22, subparagraph C of Mr. Mascarenhas' witness statements that those without prejudice discussions occurred in late 2024, not in early 2025, because he says that those discussions took place at around the time of the Black Cube investigation. And just to give your lordships the dates, the first call with X, which happened by Zoom, I think was 10 October 2024, and the meeting and the dinner in the foreign country was early November 2024, and the claimant's evidence is that the Black Cube agent immediately uploads the recording to the server, and that Black Cube then sends it directly to the claimants upon the conclusion of the investigation. So we infer that at some point in late 2024, at the latest, when these without prejudice discussions take place, the claimants have viewed the recordings. What I don't know is whether Ennio refused to read it before or after the without prejudice discussions. We haven't been told that. But what we do know is there is a point in the story before LK Law are instructed, when Ennio is still on the record, when the claimants make the decision to view, and then Ennio say, we won't look at it. They sack Ennio and they go to LK Law. And we do say that is an aggravating factor. You won't have it in every privilege hunting case. My Lord Justice Phillips is right in that even if they'd simply destroyed it, my case would be that there's an abuse. But your lordships may reject my submission based on my first 4 points, that is enough. If you do reject my submission, I say this is an additional factor that supports my case that they should be struck out. So that's that point. There is then, we would suggest, a further aggravating factor, which is LK Law's decision to view and deploy the recordings. I should immediately clarify, I'm not making any kind of professional conduct point or any point about the SRA rules. I'm making a different point, which is that the failure of the claimant solicitors, new solicitors, to do what Ennio did is contrary to what the authorities say that a solicitor should do. And since, of course, the claimant's new solicitors were acting for the claimants, that is an aggravating factor that feeds into the choice of sanction. So the question then is, what is a solicitor required to do if they receive apparently privileged communications of an opposing party? We say there are 3 reasons why it's improper to look at it. And for the court's note, this is addressed at paras 107 to 109 of our skeleton. The first reason is an analogy with the point my lord mentioned a few minutes ago, which is the rules about inadvertent disclosure of privileged documents in the CPR. The rule itself is not controversial. It's CPR Practice Direction 57 AD para 19.2. What it says is that if an apparently privileged document is inadvertently disclosed, it's not uncommon actually in major disclosure exercises, the rule is the recipient cannot read it. If they want to read it, because they think for whatever reason it's not privileged, they're required to apply to the court for directions, and then the court will decide what should happen. Now, this is not a case in which that applies in terms, because they didn't get this stuff through inadvertent disclosure in a disclosure exercise. But our submission is that if a solicitor-client communication that is inadvertently disclosed can't be read by the recipient, it would be surprising if somebody who acquires it wrongfully is in a better position and can read it and form their own view about whether the iniquity exception applies.
Your skeleton says in paragraph 107, it would be surprising if the position were otherwise where the document is obtained wrongfully rather than inadvertently. Here, of course, we're not concerned with documents at all,
no,
as I understand it, but presumably you would adjust that to say that the same principle applies by analogy to information.
Precisely so, my lord. We should have put it that way. Because of course, privilege attaches to anything that is secondary evidence of privileged communications.
The CPR rule was based upon well-established common law principles anyway, was it not?
Indeed. I mean, I'm just referring to it because it's now a convenient codification of the rule, but your lordship's absolutely right. That's my first point. My second point is there's actually authority in terms that deals with this. The leading case is L&K, which is volume 2, tab 25, page 579. So again, just to summarize the facts, and this is a family case, and Mr. Justice Mostyn was dealing with documents, not just privileged documents, but any confidential document that's wrongfully obtained. And it's at page 596. We could go to that, please.
Very sorry, I missed that reference.
Page 596.
Of what?
Sorry, volume 2, tab 25, page 596.
Thank you.
Paragraph 54, the learned judge says, in this case, the wife had copied a number of documents belonging to the husband, so that's what happened. Then at 56, he sets out general principles. Whatever the historic practice and however alluring the argument for pragmatism and practicality, it is simply and categorically unlawful for a wife, for it usually is she, to breach her husband's privacy by furtively copying his documents, whether they exist in hard copy or electronically. There may be factual issues about whether the documents were actually in the husband's private domain, but if they are, then it is wholly impermissible for the wife to access and copy them. Then picking it up at 3, if a wife supplies such documents to her solicitor, the solicitor, emphasis in original, must not read them, but must immediately seek to obtain all of them from the wife and must return them, and all copies, hard and soft, to the husband's solicitor if he has one. The husband's solicitor, who owes a high duty to the court, will read them and disclose those of them that are both admissible and relevant to the wife's claim. Now, again, pausing there, I accept this is only a point I make again by analogy. But what is clear from L&K is that if one party obtains even non-privileged documents of an opposing party unlawfully, so in breach of confidence, and provides them to their own solicitor, the recipient solicitor is under a duty not to read them, and instead to hand them over to the opposing solicitor, if there is one, who is, of course, as an officer of the court, required to disclose the documents if they are disclosable. Again, we say it would be surprising if somebody who obtains documents or apparently privileged information wrongfully could be better off than the solicitor that Mr. Justice Mostyn is concerned with here. But that's the consequence of my learned friend's case, which is if you get apparently privileged information of an opposing party and you're a solicitor, you can read it, and if you form the view that the iniquity exception applies, you can deploy it. And that's very unlikely in our submission to be the law. It's not consistent with the rationale behind L&K. Just to give the court a reference, lest it be suggested that this is a family case and different principles apply. That's not right. This was cited with approval by this court in the Nigeria case. I mean, cited with approval is a slight overstatement. What actually happened was, it was argued in the Nigeria case that L&K was wrongly decided. That's just to give the court a reference.
Mr. Justice Mostyn was famous for saying that principles decided outside the family law context didn't always apply within it. But you're saying that the converse is not.
Indeed. I think he makes some observations in this very.
Justice Mostyn's view.
Anyway, so in Nigeria, to give the court a reference, the argument advanced by my learned friend who appeared in that case, paragraph 54 at page 1413.
So which bundle are we in?
Oh, sorry, this will be volume 4. Volume 4, tab 47. The argument was that Mr. Justice Mostyn in L&K, his analysis is in conflict with the ratio of Hildebrand and Cengiz. That's the argument, paragraph 54, page 1413. The court rejected that. That's at paragraph 166, where, albeit without citing it, essentially Mr. Justice Mostyn's approach is endorsed. Page 1442, paragraph 166. This is where a solicitor obtains from his client the other side's privileged documents, etc. So it's a principle of general application in our submission. And just to give the court one other example of the operation of this principle, indeed, this is an example of what my Lord Justice Phillips said, namely, what's now in the CPR actually just reflects the common law. Example of that is Darby and Weldon, number 8. That's Authorities, volume 1, tab 4, page 40. Page 40. So what happened in this case was that Lovers, who were the plaintiff's solicitors, inadvertently disclosed some documents which were said to be...
I'm very sorry, I've got the wrong reference.
I'm so sorry, my lord. It's volume 1, tab 4, page 40. So what happens here is that Lovell's inadvertently disclosed some documents which were said to be privileged. The defendant sought to use the documents. Plaintiffs applied for an injunction. Now, one of the documents which was said to be inadvertently disclosed was described as document H. And document H had a yellow sticky, the kind that's now commonly used, which said privileged on it. But the recipient solicitor read the document anyway and requested inspection of it. One sees that at page 57, where the yellow sticker is referred to. Letter E, page 57. Now, Mr. Justice Weinlord says, whether any of the documents now in dispute originally had yellow stickers on them or not, the defendant's solicitors should have been put on notice by the yellow sticker on document H, even if it had not been obvious from the contents that it was privileged and had been inadvertently disclosed. At the very least, they should not have inspected or taken any copy of the document without first inquiring whether it had been inadvertently disclosed. So as we read that passage, what the learned judge is saying is, if you get a document which looks privileged, the only proper thing to do is to ask them, have you given it to us inadvertently? You can't, as it were, read it and form your own view. As it happens, that was the advice given by leading counsel in this case, which the client ignored. And that is set out at page 65. picking it up at letter E, what the defendant's solicitors prudently did, as they have candidly disclosed in evidence that has been filed, when they saw that they were apparently privileged documents, a phrase that we rely on, with yellow stickers or not, was to seek advice from the first two defendants' leading counsel. The advice that leading counsel predictably gave the solicitors was that they should get in touch with the plaintiff solicitors and ask them whether they had intended to disclose privileged documents or whether there was a mistake. The solicitors for the first two defendants, however, discarded leading counsel's advice, instead without disclosing any suspicion, etc. So Darby and Weldon, we would submit, is another illustration of the principle that to read apparently privileged documents of an opposing party is improper, even if, having read them, you contend for one reason or another that privilege doesn't apply. That's our second point. Our third and final point in support of why we say the claimant's new solicitors were not entitled to do what they did is a point I briefly mentioned yesterday when I responded to my learned friend's appeal, which is that on the current state of the authorities, if there's a dispute about whether the iniquity exception applies to a particular document, even the court will not look at the document itself to resolve that dispute, save in exceptional circumstances. The leading authority on that is C&C, which is Authorities Volume 1, tab 14, page 325. Again, just to save time, perhaps I can quickly summarize the facts. Another family case. This concerned an expensive London property, which was the former matrimonial home of the couple in question. The wife issued her divorce petition on 21 November 2005. The day after that, she obtained an ex parte freezing order against the husband. The order was subsequently varied to permit the sale of the house, but the seller and the owner of the house was a Liechtenstein Anstalt, and the wife's case was that the Anstalt, which I am afraid I may be mispronouncing, was the husband's alter ego. She issued a disclosure application seeking disclosure of the conveyancing file of the Anstalt solicitor. You can see that at paragraph 9 at page 328, which says, on 1 December 2005, the wife applied for an order that representatives of the Anstalt's conveyancing solicitors X attend an inspection appointment to produce in the case of X the conveyancing file. They said we won't do it because it's privileged. She said, well, the iniquity exception applies. One can see that at para 34, page 334. Where the judge considers whether the iniquity exception applies. It was then commonly called the fraud exception. Now, what's important about this case is Mr. Justice Munby approaches this question in two stages. First, he asks, is the iniquity made out independently of the conveyancing file? By reference to other evidence, can you show the alleged iniquity to the relevant merits test? He concluded the wife could not do so. That's para 62, page 342. Where he says, on the contrary, there's uncertainty, the 3 lines from the bottom, the wife, in my judgment, has failed to satisfy the heavy burden which rests upon anyone who, in a case such as this, seeks to go behind privilege on the ground of fraud. The wife then ran a fallback argument that the court should look at the conveyancing file itself to see whether it discloses the alleged iniquity. One sees that at para 64. And the learned judge rejects that at para 67, which contains the statement of principle on which we rely. I think that the court undoubtedly has to, the power to examine the document should be exercised very sparingly. I'm prepared to assume that people may find it less worrying if their solicitor's file is being examined by a judge rather than a policeman. But if the papers are indeed privileged, then the privilege will have been invaded just the same. Privilege is in principle absolute, too ready a judicial willingness to exercise a power to inspect might well have a seriously chilling effect on people's confidence that what they say to their lawyers will not be disclosed, and a seriously chilling effect, therefore, on their willingness to speak frankly. And finally, those who cannot meet that demanding test should not be allowed to go on a fishing expedition, and it makes no difference for this purpose that it is the judge rather than the litigant who is casting the net and inspecting the catch. So that would appear to be the origin of the exceptional circumstances test. It's put in terms of very sparingly. And just to give the court a reference, this is cited and followed by Mr. Justice Norris in the BBGP case, Authorities, Volume 1, Tab 21, page 493. Indeed, since it's in the same volume, perhaps we should just quickly look at it. It's page 493. Bottom of the page, there's a reference to this case we just looked at, C&C. And then just above letter C, the applicant failed to make out a strong prima facie case. The judge held that having failed to gain entry through the front door, she should not be permitted to seek her objective by inviting the judge as a surrogate to make a surreptitious entry through the side door. And then, just below letter D, as a rule, the court should not look at the closed material. There must be some exceptional factor or real weight before the court can examine the closed material to see if the test for disclosing the closed material is itself satisfied. The mere fact that the test is not satisfied on the open material is not such an exceptional factor of real weight. No exceptional factors are identified in argument. I therefore confine myself to the open material. I accept that this is all first instance, but there are no...
This point generally arises when the person seeking to get the material doesn't have it and doesn't know what it says.
Yeah.
Plainly see that you have a system in which they get to see it for the purposes of arguing that the privilege is not engaged because the iniquity rule, that would defeat the entire point.
Yeah.
And so you don't have the judge being used as a fallback. I'm not saying it should lead you to be in any better position, but the reality here is if there were to be an argument about iniquity status, it will be one that will be conducted at the moment on the basis that both sides would know what the material said.
Yes, but the consequence, if these cases are good law, is that the court would conduct the inquiry without looking at the closed material. It would ask, can they make good the alleged iniquity without looking at the black? I mean, I see why your lordship is putting the point to me. It seems a bit counterintuitive, and both parties know it, for the court to have to make the decision without looking at it. But there's important public policy rationale for this, which is especially the iniquity exception.
No, I can see you should say, well, you couldn't be any better off by getting your hands on it.
Indeed, that's the difficulty here.
You will have a situation where, let's say, documents have been disclosed, and then one party says, oh, we made a mistake, they're privileged.
Yeah.
And the party who's received them says, well, it may have been a mistake, but they're not privileged. Well, the judge would definitely look at the documents then, wouldn't he or she?
That's true, but it depends on the ground on which they're saying it's not privileged. If, for instance, what is being said is it's not privileged because, say, the Three Rivers number 6 test, which contains the narrow definition of client, is in not iniquity, in other words, something else, then these authorities are not in point. These authorities are about when can the court inspect in order to resolve a dispute about the iniquity exception.
But picking up my Lord Justice Phillips' point, is it really the case that if there's been inadvertent disclosure, which someone has got far enough into, which actually you sometimes can do without realizing, by the time you work out they may be privileged, you may have detected an iniquity argument. If there was then an attempt to say we should not have to hand them back in a hearing before the court, and the reason relied upon was the iniquity exception, is it really the case that that entire argument is conducted without reference to the contents of the documents themselves?
In my respectful submission, yes, but only for this reason, which is one only ends up in that situation if one has failed to comply with Practice Direction 57 AD, para 19.2, because the moment an apparently privileged document is inadvertently disclosed, the rule is you're not allowed to read it. If you choose to read it and then you say, well, an iniquity exception is engaged, you shouldn't be better off when you have the argument in court than you would be if you had complied with your obligations.
Well, I find this difficult because let's imagine that there is a letter of advice, undoubtedly on its face a privileged document, but when it's read, it is seen that solicitor is advising the client in great detail how to perpetrate a crime stroke fraud. Now, it's quite clear that is not covered by privilege. The idea that you would somehow then have to say to the judge, well, this document isn't privileged, without being able to show them the letter, seems to me would be a nonsense. You would say to the judge, this document is not privileged because it is advice on how to commit a crime. I don't see how at that point, if the other side maintains it's still a privileged document, how the judge will not look at the document.
But it seems to me, my lord, there's a prior stage in the analysis, which is when your lordship says there's a letter of advice in which the solicitor is sort of hand in glove with his client, advising him how to commit the fraud. The recipient will only know that if they've read the letter in the first place. And what the authority says, you can't do that. And the reason you can't read an apparently privileged document is what Mr. Justice Munby says in C&C, which is otherwise privilege is too easily invaded. It is, of course, true that once you read it, it seems counterintuitive to conduct the argument without reference to the document. But the only reason one is in that counterintuitive position is the recipient's
What we're
wrongdoing.
talking about now is whether or not the court can read it. And
Yes.
if both parties know what's in the document, there is no principle which would be offended by the court also knowing what's in the document. The point about Mr. Justice Munby's concern at that point was that there's no reason why the court should see what's in the privileged material. The wife didn't know what was in it.
But that's right. But that means that the wife, having complied with her obligations, is worse off than if she hadn't. Because if she hadn't, if she had read the stuff when it came over to her, suppose the conveyancing file had mistakenly come to her, and she had said, by contrast to what happened in Derby and Weldon, I'm going to read it, her knowledge acquired in breach of her duty would then be relied upon as an exceptional circumstance to enable the court to look at it. But I see what your lordship.
But in this situation, you would have the recipient might have acted wrongly by looking at it. But what they have seen is that the defendants and the solicitor were engaging in a criminal conspiracy and were now seeking to cover that up by maintaining wrongly that the document was privileged. It would be a total perversion if they could get away with that by saying to the judge, well, I'm terribly sorry, it's prima facie privileged, so you can't look at it, even though both we and the other side know exactly what's in it.
I understand that, my lord.
Unrealistic.
I understand. The difficulty is that what your lordship is positing is a very clear case in which the letter of advice discloses an iniquity. In most cases, in practice, there will be a dispute about that. If if you imagine that situation where there's a dispute about whether there's iniquity, and there's a dispute
All the more reason why the judge needs to see it.
but that then involves saying the exception circumstances test doesn't apply, and it may be that's what the court will say. But the rule appears to be, as I accept at first instance,
Well,
the
what
opposite.
it's saying is that you only look at documents, the court only looks at them when they are not otherwise known to assess whether they're privileged. But when both parties have seen the documents, what's the principle or policy which means that the court can't see them?
Your lordship has my submission. It's simply that if the reason why one of them saw it is itself a breach of duty, that should not enable them to ask the court to do something which they wouldn't otherwise be able to do. But I think your lordship has my submission. I also have my other points about why the claimants solicitors were not entitled to look at this stuff. That's all I wanted to say on the fifth of my 7 points. Moving very quickly to the sixth, which I can take shortly, is that even without the information review hearing, it's clear that the abuse has already caused prejudice to the defendants. They've lost their solicitors. But even before one gets there, the claimants have got a vast amount of sensitive information about this litigation, which they would not have got but for the abusive conduct. And that is so even if the information is not privileged. Because even if the information is not privileged, the claimants never had any means of compelling X to reveal his thinking about all of these things. So whatever the outcome of the information review hearing, if the claim survives this appeal, what we would submit is clear, is that the claimants have obtained a very significant benefit by reason of abusive conduct.
something that could never have emerged from the disclosure process, even
it
if
never
there were
emerged.
documents to which the iniquity exception applied.
Precisely, and that's a key distinction in Rakia. And Mr. Hausman Casey, and we respectfully agree, makes the point in a number of passages in his judgment that once you get this stuff, your corporate mind cannot unknow it, and there is no way to police its influence on the course of the litigation. It is impossible. If only the lawyers know it, which I think is what happened in the Appellant case. So only the lawyers know it, then the court can simply say, you have to change your legal team. But the vice here is that the claimants know it. That's the problem. So that's the prejudice point. Turning finally to our seventh point, which is a new point, albeit it also emerges from the unredacted black cube retainer, which was sent to us. I don't know if it's made its way to your lordships.
Yes, we got that. Thank you very much.
Yeah, grateful. So our seventh point in support of strikeout is simply this. If your lordships are re-exercising the discretion, it is my learned friend's own case that you should have regard to all the circumstances, and that must include in our submission findings made by the learned judge about the claimant's conduct, not just the black cube conduct, but even their conduct of this application and litigation. So 3 examples. First, at the hearing below, the claimants contended that privilege in the information obtained from X was waived because X chose voluntarily to reveal it. So not iniquity, but waiver and loss of confidentiality. In other words, their case was that confidentiality in information obtained from a person by lying to them is lost merely by virtue of the fact that the lie is successful. It is also one of the reasons given by Mr. Ford of LK Law for his decision to look at the black cube recordings. Just to give the court a reference, that's Ford 2, para 14, supplemental bundle, tab 19, page 315. Now, at para 65 of his judgment, the learned judge not only rejected this argument, but described it as unconscionable.
I mean, it's not exit privilege to waive amongst many other
Precisely.
objections.
Precisely so, my lord. One might have thought that that observation would have caused the claimants to reflect, but their response was in fact to ask the learned judge for permission to appeal on this point, which was not only refused, but was accompanied by an observation by the learned judge that the point is quote-unquote distasteful and graceless. The claimants then sought permission to appeal from this court, which my Lord Justice Nails refused, describing the point as absurd. That is co-bundle, tab 11, page 148, paragraph 4. This point is obviously not going to get me home on its own,
No.
but I make it because it is of a piece with the claimant's approach more generally, which has been to avoid acknowledging the gravity of their wrongdoing and to react to judicial criticism, not with reflection and reconsideration, as one might expect of litigants in the commercial court, but instead by doubling down. Indeed, in his consequentials judgment, the learned judge observed that the claimants did not offer any apology to the court for what is on any view abusive conduct, nor, so far as we are aware, have they offered one to this court. And the learned judge, in fact, ordered the claimants to pay the costs of the hearing below on the indemnity basis, not only by reason of the original abusive black cube conduct, but because he found the conduct of the hearing independently was outside the norm and justified indemnity costs. And that's co-bundle, tab 9, page 140.
Well, I can see that taking a bad or even a very bad argument might justify indemnity costs, but it's a bit hard to think that it justifies striking out the claim.
Or
So,
indeed adds materially to the balance.
no, but it's not just taking a bad point, my lord, because the learned judge refers to various other things. And I've already accepted it's not going to get me home. I don't want to say make-weight, maybe it is a make-weight point, but there's some...
Although the judge did, in paragraph 78, treat as one of his 5 factors against strikeout what he called the independent responsibility and culpability of X.
Yeah.
Presumably you say he was wrong to.
Yeah, that's one of the last 2 topics I need to deal with. That and his point at 78.2, which is his big point, that there's a decent prospect of the fraud claim succeeding, and that has to be weighed as a countervailing indication against strikeout. That's the only two things I've got left, I'm pleased to say. So I will finish with your Lordship's indulgence shortly after the short adjournment.
Right.
Just very quickly on this point, in the consequentials judgment, just to answer my Lord's question, para 19 at page 143, it wasn't just the fact that they took a bad point, which resulted in indemnity costs. The learned judge says various other things. For instance, in 19.1 at the bottom of 143, then 19.2, 19.4, they put in evidence which was selective, incoherent, incredible, etc. So I don't put it higher than to say that your lordships are entitled to have regard to this in re-exercising the decision. And my last point arises out of the unredacted black cube retainer, which I imagine the court may have seen. Now, what tends to jump out is that at clause 19 of the unredacted retainer, page 5, it says that if Black Cube is asked to provide a witness statement, they are to be paid a fee of £220,000. In the quote below, the claimant's evidence included 3 witness statements from Black Cube, Dr. Avi Yanis, but the learned judge was not told that Black Cube were paid for that evidence, even though we would suggest it is, to put it at its lowest, relevant to the credibility of that evidence. That's clause 19, which says $220,000 for various things, one of which is if you're asked to provide a witness statement. The claimants then, my lord may recall this, the claimants then applied to this court for permission to appeal virtually every factual finding made by the learned judge, which my lord, Lord Justice Males, refused. But the interesting thing about the permission application was that the central argument being advanced was that the learned judge was wrong because he didn't accept the evidence in the Black Cube witness statements. But this court wasn't told that Black Cube had been paid either. Indeed, the PTA skeleton said that the Black Cube evidence was quote-unquote a complete answer to the learned judge's factual findings. Finally, clause 21 at the bottom of page 5 is somewhat unclear. I've read it a couple of times, but its effect appears to be that if one looks at the first sentence, in the event that the intelligence sourced by Black Cube is used. So the effect of 21 appears to be that if the intelligence sourced by Black Cube is used and the claimants, then Black Cube is then entitled to a success fee of 4% of the total amount of value received by the claimants. Now, the learned judge points out that when the summary judgment application was made on the 5th of March 2025, it relied on and used the Black Cube intelligence, exhibited the recordings. So if the summary judgment application had succeeded, judgment would have been entered for damages to be assessed, which the claimants were saying at the time were around $315 million. If that's right, the position...
Is that a figure inclusive of interest?
I don't know the answer to that. I'm getting the 315 figure. That was the amount of the conditional order they sought in the alternative to their summary judgment application, which is simply damages to be assessed.
Not inclusive of interest, as I understand it. Sorry.
I'm grateful to my learned friend for that application. So 315. So
I thought I got a figure that it was 271 million, which had, as it were, gone missing to your client. But maybe I got the wrong figure.
I can certainly check that over the short agenda. But the point I was going to make is that the position appears to be that Black Cube, which gave evidence in support of the summary judgment application, stood to make potentially $12 million if the application were to succeed. And as I say, that wasn't disclosed to the learned judge. So those are the 7 reasons why, if the discretion falls to be re-exercised, we invite your lordships to strike the claim out, alternatively to discharge the freezer and permit the undertaking to be enforced. That takes me finally to issue 1, but I'm not even sure it arises, issue 1, because unless your lordships were to reject the analysis put forward by both sides and were to say that the learned judge got everything right, including striking the summary judgment application out as a sanction, the discretion is going to fall to be re-exercised. But what I wanted to deal with were 2 points mentioned by the learned judge at paragraph 78, because they are also relevant, if they are good points, to the re-exercise of the discretion. The first is paragraph 78.2, which refers to the substance of the claim. It's a point the court put to me yesterday, and indeed my Lord Justice Phillips put it to me today as well, which is, should it not be weighed in the balance, that the consequence of striking out might be that a fraudster gets off. That raises not only factual questions, but a point of principle, and that's what I want to focus on for the short adjournment. As a matter of law, is the nature or strength of the substantive claim legally relevant to the choice of sanction for an abuse, especially an abuse of this kind, which takes the form of subverting the system? I don't want to go further than I need to go, so I don't need to say that it is irrelevant for every conceivable form of abuse, but we do say it is legally irrelevant to the choice of sanction for an abuse that takes the form of cheating the system, as the learned judge found. In their skeleton argument, my learned friends say that this submission that I've just made is contrary to various authorities, which I'll deal with. But in the first instance, I just want to identify various reasons, a matter of principle, why we say that the merits, both the nature of the claim and the strength of the claim, is legally irrelevant. The first point is one I've made, so I'll make it very shortly. If the court takes the nature of the claim into account in choosing a sanction, then the sanction for the same abuse will vary according to and only to the nature of the claim, which we would suggest is not only contrary to principle, in that it involves treating like cases differently, it also has the undesirable consequence of sending a message to litigants who set out to cheat the system, that there is a balancing act between the cheating on the one hand and the nature and strength of the substantive claim on the other hand, which is not, we would submit, a position that English law should adopt. That's point one. Point two. If the court takes the nature of the claim into account, so the fact that this is an alleged fraud, that would give rise to an unprincipled distinction between claimants on the one hand and defendants on the other. If a claimant goes privilege hunting, they would be able to say on the learned judge's approach, and my learned friend's case, that the fact that they have brought a fraud claim should reduce the sanction that would otherwise be appropriate for their abuse because of the public policy of holding alleged fraudsters into account. But if a defendant goes privilege hunting, they would ex hypothesi be unable to say that because a defendant, ex hypothesi, isn't bringing a claim, leaving aside cases where there's a counterclaim. What I'm positing is,
it might be a reason why a defendant facing a fraud claim should not be deprived of the ability to defend allegations of dishonesty that would have very serious implications for them if they went by default.
but the Van Hoogstraten case, where the defense was struck out, I'll check, but I thought by amendment Mr. Raja introduced allegations of dishonesty against Mr. Van Hoogstraten.
But yes, I'm not sure the fact that it was a factor in play in another case answers the fact that there may be defendant-specific factors as well as claimant-specific factors that turn on the nature of the claim.
No, of course. But in the Canadian case, because of the time, I won't go to it. In the Canadian cases, there are some cases where a defense has been struck out on the ground of privilege hunting, which will have the consequence either of enabling the claimant to get judgment in default, or if they want it, because they want to enforce abroad, a substantive judgment if they prove their case. So there's no conceptual reason why a defense can't be struck out. I take my Lord's point that one might have to look at defendant-specific factors. But the difficulty about taking the nature of the claim into account, of saying things like the public policy of holding fraudsters to account has to be weighed in the balances, that is only claimant-specific. And it would mean that as serious or more serious an instance of privilege hunting by defendant attracts different remedial consequences, which we suggest there's no obvious reason why that should be the case.
It does, indicate there is an issue in relation to your overall overarching contention that the right answer is effectively almost always to strike out, which is that that's all very well if it's a claimant, but it isn't necessarily so easy to see if it's a defendant.
Well, first of all, I don't need to say nearly always strike out. I mean, that may be a logical consequence of my case, but it's sufficient for me if the discretion is being re-exercised for me to persuade your lordships that the appropriate re-exercise of the discretion on the facts of this case is for the claim to be struck out, whatever the consequence may be in other cases. I only need to go further if your lordships are not persuaded that the discretion falls to be re-exercised, and I need to show the learned judge's decision was perverse or plainly wrong or anything. But on your lordship's second point, it doesn't seem to us there's any conceptual reason why a defense can't be struck out. I mean, it happens with unless orders. Sometimes a defendant is ordered to put up security for costs. They don't do it. There's an unless order. They don't pay up. The defense gets struck out. And there are other procedural contexts in which a defense will be struck out. And the consequence will simply be that you can get default judgment. And I think the authorities say that if you apply for default judgment, whatever primary facts you've alleged in the particulars of claim are taken to be true. The court doesn't go behind that. So you will get whatever relief you are entitled to as a matter of law on the facts that you've pleaded. So
that is the distinction, isn't it? Is that the claimant's claim is struck out regardless of any merits, whereas if you strike out the defence, the claimant only gets what he's entitled to on his pleading.
But only as a matter of law, because the default judgment authorities say that the court won't go behind anything that's asserted in the particulars of claim. So if you've pleaded a cause of action which is recognized by law, so for instance, if I plead fraud or I plead breach of contract, the court won't investigate whether the breach actually occurred. That's taken as read. All that the court will ask is, should I get an injunction, or what is the form of relief to which I'm entitled? So there isn't necessarily, we submit, any anomaly. One can treat defense and claims alike. And that takes me, before the short adjournment, to what it seems to us is a key point, which is taking the nature of the claim into account would introduce difficult distinctions between the law relating to abuse of process and other areas of the law in which this court has said that the nature of the claim is irrelevant, notwithstanding the same or similar public policy pointing the other way. A striking example of that is to be found in the judgment of this court in the Good Law case, which is Authorities, Volume 2, tab 37.
So here we are striving for coherence with other related areas of law.
As distinct from, well,
Our conversation yesterday.
although we would say, I mean, I don't want to go that ground again, but we would say that the approach for which we are contending is in fact more coherent because it coheres with the criminal law, whereas my learned friend doesn't. Anyway, the Good Law case is tab 37, page 887. Again, very quickly to summarize the facts, an interesting case. What happened was that the Good Law Project, which is a not-for-profit organization, issued a judicial review claim form challenging the lawfulness of a public procurement exercise for the supply of PPE during the COVID-19 pandemic. In pre-action correspondence, Good Law were told that any claim form should be served on the Treasury solicitor. My lord will recall this case. Treasury solicitor by email to a particular email address. But Bindman's, Good Law's solicitors, sent the unsealed claim form to that email address, but sent the sealed claim form once they got it to a different email address. As my Lord Justice Phillips observed in his dissenting judgment in this case, this did not cause any prejudice to the defendant because it not only knew about the claim, it had also received the sealed claim form, just at a different email address, and had acknowledged receipt of it. So it's a pretty technical point in one sense. Despite that, the learned judge at first instance held that service was defective and declined to exercise her power under CPR 6.15 to cure it. And this is the appeal from that. And one can see at paragraph 5 of the majority judgment at page 890, that Goodlaw's case on appeal was that this is why the case is relevant for our purposes. Goodlaw contends the judge was wrong to bring to an end a claim of potential significant public interest on account of an error in service and delay which could not have been more technical. So what the claimant was saying was that the nature of their claim, the nature of the substantive claim, that is to say, a claim of public interest, is a relevant factor to the exercise of the court's power under CPR 6.15, whether to validate a defect in service or not. But the majority rejected that contention and did so expressly. That's at para 70 at page 900. What Lady Justice Carr said is, further, I do not consider the public interest factor relied upon by Goodlaw to be an independent compelling reason in favor of granting the application. The rules apply with a public interest element with as much force as they do to any other type of claim. It would be both undesirable and unprincipled, which we respectfully agree with and adopt, for the outcome of an application under CPR 615 to be influenced by reference to the nature or importance of the claim in question. And then just picking it up near letter F at the bottom of that paragraph, there is no reason why a failure validly to serve a claim that raises questions of public interest should be treated more leniently than a failure to serve a private law claim, which may be of equal, if not more importance to these litigants.
I think what degree of care is required in how far one rolls out that approach. I think Denton and White considerations of response to breaches of rules routinely look at the strength of the claim as a relevant factor, and there are other contexts when that would be, I think, an appropriate factor to take into consideration. I suspect you get it on applications for extension of limitation periods in personal injury cases and other examples.
Yes, but my recollection is that even in the relief from sanctions context, the merits are only taken into account if they're very strong or very weak, so close to summary judgment stand. It's not the mere fact you're alleging a fraud claim that would be taken into account for relief from sanctions. And one can think of various other procedural contexts in which it wouldn't be. For instance, I mean, that's the point I was going to make.
Yeah, yes, I mean, the relief from sanctions cases say pretty clearly, as I recall, that the court is not to engage in a mini-trial on the merits.
Precisely. So,
but if there's a particularly clear case, and again, security for costs, I think you get this as well. There's a general reluctance to quite probably not to try the case at the interlocutory stage. But it can be a case of sufficient clarity that it becomes irrelevant.
Yeah, so I'm trying to make two different points. One point that's taken against me is the mere fact they've alleged fraud should reduce the sanction, which your lordships would otherwise consider appropriate because of the public policy. And indeed, the learned judge only says decent prospect. He doesn't. So to the extent the case is put that way, we submit that it's very difficult to reconcile with good law. One can posit, I was just going to say before.
I suppose if we're looking for coherence across different areas of the law, you would probably say that it's a bit strange that somebody who serves the sealed claim form on the wrong email address in a way which causes absolutely no prejudice gets their claim struck out, whereas somebody who engages in privilege hunting doesn't.
Precisely so. Indeed, the way to test it is, imagine that instead of a public interest claim, I mean, it wouldn't have been good law, but imagine they brought a fraud claim. As we read paragraph 70, that wouldn't have made any difference to the analysis. Lady Justice Carr would have said, I imagine, exactly the same things that she did say, whether it's fraud or public interest. And as I read the dissenting judgment of my lord, the disagreement wasn't actually about this point, namely the relevance or otherwise of the nature of the substantive claim. Rather, my lord would have allowed the appeal on the ground that the defect in service was technical, there was no prejudice. That's at para 92. So while I don't say that my lord endorsed para 70 of the majority judgment, I don't detect any disagreement with it. And it seems therefore...
the appeal was dealing with the very technical rules of service and whether or not, by virtue of the way in which service took place, there should be an order under 615 to effectively validate what had been done. And nobody was disputing that on issues of service, you take into account simply the merits of the position in regard to service.
Service, yeah.
But that's a long way from the situation we are in here, where we are looking at extant proceedings, validly served, validly constituted, and whether the party who has so brought them should be driven from the judgment seat by virtue of other conduct. And that seems to me we're in a very different world.
We are in a different world, my lord, but if I may respectfully say, my submission is a difference in my favour, not against me. For the reason my lord just put to me. It's a point also made by Lord Reed, exactly this point, which I should show your lordships. Volume 5, tab 61. I'm sorry to take this so quickly, it's only because of the time, and I want to make sure I finish well in time. Volume 5, tab 61, page 2032, which is the lecture we looked at earlier from Lord Reed. Is the second paragraph. So, if your lordships have the sentence beginning with "in that context," where
I'm sorry, which page?
Sorry, 2032.
Thank you.
Second main paragraph, starting with "this approach is also consistent with," about 5 lines into the passage. In that context, where the dismissal of actions will be in greater use as a sanction for non-compliance with the rules of court, there may be a greater readiness to dismiss actions which constitute an abusive process. It makes little sense to be willing to dismiss an action for non-compliance with the procedural rule and the consequent waste of time and money, but to forbear from doing so when a similar or greater waste has been occasioned by a litigant's dishonesty. We respectfully agree with and adopt that, and one can test it in this way. Imagine that in this very case, they had issued the claim form on the cusp of the expiry of the limitation period for the fraud claim, and they'd got service wrong, some technical defect in service. Say my client subjectively knew, or as in the good law case, there's no prejudice, but they need to rely on some procedural power to validate defective service. As we read good law, the fact that they were bringing a fraud claim would be legally irrelevant, notwithstanding the public policy to which the learned judge refers of holding alleged fraudsters to account. And we do say that it would not be coherent for English law to adopt the position that if you make a mistake in serving a claim alleging fraud, you lose the ability to pursue the claim. But if you seek deliberately to subvert the adjudicative process by cheating the system, you can pray in aid the fact that you have brought a fraud claim to avoid the sanction that would otherwise be appropriate. It's very difficult in our respectful submission to see why the law would wish to adopt that position. Very quickly, a few points on principle, then I need to deal with rakia, which is really the high point of my learned friends' piece. If, contrary to our case, the nature of the claim were capable of reducing the sanction for privilege hunting, and one's got to remember, when one says, is the nature of the claim legally relevant, what one is really asking is the nature of the claim capable of reducing the sanction? Because that's the only direction in which it can ever go, the fact that you're alleging fraud. If that were possible, legal professional privilege would actually be less secure for defendants who have a greater need for it, namely those accused of serious wrongdoing. Sometimes people who are accused of serious wrongdoing did not do anything wrong, and we say this is such a case. And if I don't run out of time, I'll say something briefly about the facts. But in either case, whether the wrongdoing is well-founded or not, it is fundamental that they are able to consult their lawyers and defend the claim. Precisely because of the serious consequences that the claim will have, given how much typically tends to be at stake, personally, reputationally, financially, where serious wrongdoing is alleged. But on the learned judge's approach, if a claimant goes privilege hunting in a case of that kind, that is less likely to attract the sanction of strikeout than, say, in a banking or insurance case, where no serious wrongdoing is alleged and the dispute is about the proper construction of the contract. finally, on principle, if we just look again at para 78 of the judgment, co-bundle, tab 8. Page 134. What the learned judge says is that there's a striking out be disproportionate in circumstances where there's a decent prospect of the claimant succeeding, and then there's a distinct policy of exposing and remedying serious wrongdoing. Now, it's not clear to us if the learned judge's view was that strikeout can never be the appropriate sanction for privilege hunting where serious wrongdoing is alleged, or if the learned judge's view was that strikeout may be justified in some cases but not others. If the learned judge's view was that strikeout can never be the appropriate sanction for privilege hunting where the claimant alleges fraud, that we would suggest is difficult to defend.
He's allowed you another strikeout application following the information review hearing, isn't he?
Yes, but on a different ground. So that's about fair trial. It may be that the abuse point features as well, but here he's dealing with what's the sanction for the abuse.
Right.
Now, if the learned judge's view was that strikeout can never be the appropriate sanction for privilege hunting where fraud is alleged, not only would that prevent the claim from striking a claim out, no matter how egregious the privilege hunting, it would actually involve introducing the very kind of hard-edged legal rule which my learned friends attack, because that would have the opposite hard-edged rule, which is you can never strike out for privilege hunting in a fraud claim. So we read this as the learned judge saying that in some cases involving privilege hunting, you can take the nature of the claim into account, but not in others. But if one goes down that path, it will become necessary in individual cases to weigh the seriousness of serious wrongdoing against the seriousness of privilege hunting. And there are, we respectfully submit, no standards or principles by which the court can weigh those things against each other. And even attempting to do it might bring the administration of justice into disrepute. Indeed, it would not, in our submission, reflect well on the common law, especially in the eyes of the public. If, for instance, the position were that obtaining privileged information by bribing a solicitor is not bad enough to strike out a fraud claim, but threatening them with violence is, or if the position is that alleged negligence by a hospital is not a sufficiently important interest to insulate a claimant from strikeout, but an allegation of fraud is. And just stepping back, if what the learned judge is saying is that you can take the nature of the sanction, nature of the claim into account to reduce the sanction in some privilege hunting cases, but not others, it's very difficult to see why this is not a case in which you exclude it, because this is about the most serious case of privilege hunting you can have. Even if I'm wrong in my more perhaps ambitious submission that this is a sort of general rule, or you should always have strikeout as the sanction, you have a case here where for $11 or $12 million, they hire ex-Mossad operatives to ask a series of detailed questions about sensitive matters. They get the recordings, they sack their solicitors, and the solicitors say, don't look at this. They then read the recordings, deploy it without prejudice meetings, summary judgment application. I mean, that is on, even within the spectrum of privilege hunting cases, it's pretty much at the highest end. So unless the learned judge is saying that you can never have regard, unless the learned judge is saying that you can never strike out a fraud claim for privilege hunting, it's very difficult to understand why this isn't a case in which you would strike it out.
This is your if not now, when submission.
Much more pithy encapsulation of what I said. Is that a convenient moment, my lord?
Yes, very well. How much longer do you think it will be?
I would hope not more than half an hour, 40 minutes at most.
Right. Which means, I take it, that there's some, but perhaps a small chance of finishing today, but we shouldn't go too far into tomorrow.
I'm sure we won't need all of tomorrow. I imagine my learned friend won't finish today, but no doubt he was saying...
All right, 2 o'clock.
All right.